this was really a victory for states' rights. This was a decision in which the United States Supreme Court said, we're going to leave this entirely to the discretion of the states. What the Supreme Court has said is that this is not a deliberative process, this Electoral College. They're not chosen to go there and sort of use their own judgment and decide how to vote. This is really to be a reflection of the winners of the presidential race and vice presidential race in the various states.
More reaction from Supreme Court rulings. You'll recall here on Court TV, historic coverage of Supreme Court arguments, live arguments for the first time ever. We covered them right here on Court TV. Never before has the Supreme Court allowed a live transmission of arguments, but they did, and we brought it to you live here on Court TV. And that case he's talking about involves the Electoral College system, okay, which was, I don't want to say under attack, but the Supreme Court had to make a decision about it. Julie Grant gives us the background.
Levi Guerra was just 19 years old when she joined Brett Schifalo and Esther John to defy their pledges to support the candidate who won the popular vote in the 2016 presidential election.
As a presidential elector, I feel a great sense of responsibility.
The candidate who won Washington state was Hillary Clinton. But the three so-called faithless electors chose to vote for former Secretary of State Colin Powell. That vote for Powell violated Washington state law, and the three electors were fined $1,000 each.
The state fined them, and so they've challenged the constitutionality of the state's faithless elector law.
The trio appealed. They argued that electors are allowed to use independent judgment when they cast their ballots. The Washington Supreme Court disagreed with them and ruled the state does have the authority to impose the fines, and their right to free speech had not been violated. But later, a federal appeals court that was considering a similar case in Colorado ruled that states do not have the power to interfere with electors' choices. Law professor Michael Morley explains why the issue now stands before the United States Supreme Court.
There was a jurisdictional split. The Washington Supreme Court had upheld that state's faithless elector law, whereas the 10th Circuit had held that Colorado's faithless elector law was unconstitutional.
That is why, as an elector for Washington state, I stand behind Hamilton electors.
Guerra was part of a group of electors that voted or wanted to vote for a candidate other than the one they were pledged to, and they attempted to influence other electors to do the same.
They were working with many electors around the country to try to convince Republican electors, 37 Republican electors, to vote for somebody other than Donald Trump. Not so that the Electoral College would pick somebody other than Donald Trump or Hillary Clinton, but so that the House of Representatives would have a chance to reflect on it. Because they thought that the idea that this system had produced a winner who had actually lost by 3 million votes was an anomaly.
The High Court had consolidated the faithless electors cases in Washington and Colorado, but they were severed in March after Justice Sonia Sotomayor recused herself from the Colorado case because of her friendship with one of the respondents. Professor Morley says the Electoral College may be at stake.
The entire Electoral College, in a sense, would be up for grabs because now states would not be able to require their electors to vote in a particular way. The other main issue is the remedy, right? Even if faithless elector laws are constitutionally valid, even if states can require electors to vote in a certain way, the other question then is, are there restrictions on how states are allowed to enforce that requirement?
In 2016, for the first time in American history, states, Washington state, which fined the electors, and Colorado, which actually kicked an elector off, states have begun to exercise the power to control the votes. And the question is whether the state has the power to control the votes, or the state just has the power to appoint electors who then, again, like any elector, is free to vote how they wish.
To me, the amazing part of this case is you got a 19-year-old, right? Very mature 19-year-old trying to overturn our entire system of how we elect a president. Let's bring in Julie Grant for the ruling and what it really means. Julie, first of all, amazing, right? 19-year-old is attempting to overturn our entire system, and we're going to have to do it differently. What's the bottom line here?
Right, Vinny. So bottom line is the states' rights prevailed here. That is the bottom line. I spoke with an election law expert today, had to just to get to the gist of this, what it means for Americans, why should we care about this? So I spoke to Professor Joseph Sabino Mistick with Duquesne University School of Law, and he told me, not only does this firm up the value of the individual voter in every state and what those votes mean, but also it eliminates the potential for chaos, right, in this whole process. And so the bottom line is, must electors vote according to the popular vote of their state? That's really the big question that was decided with these cases. And basically the answer is yes. I'll let Professor Mistick explain it better now.
Each state is free to set the rules as it sees fit. And so far, many of them have regulations that actually by statute bind the electors to the winner of the popular vote in their states. Some states do not have that specific piece of legislation. However, the Supreme Court decision was so sweeping. Keep in mind, it was a rare unanimous decision too by the court, but it was so sweeping that there's reason to believe that even if a state does not have that law in place, they can still remove or discipline their members of the College of Electors.
All right, so there you have it there. So every state, because of course states are sovereign, they have the right to do things differently. But at the end of the day, Vinny, these electors can't just go rogue and vote however they want. Like he said, it's not a deliberative process. They're not to weigh this and make the decision for the people. No, the people speak, and it's going to be followed through with.
Now, part of the basis for this whole case, as we learned from your piece, was the popular vote. What about a national popular vote?
Right. It's something, it's funny. I spoke with a professor about this, and he gave me a little bit of a history lesson with that. And it's funny how our founding fathers, he was talking to me about Madison and Hamilton, and they were thinking about the notion of having a national popular vote, but decided against it to avoid factionalism. And he was saying it's funny how now the Supreme Court in this decision, that's what they're trying to avoid too, right, is factionalism. And so he was saying something else that really kind of blew my mind. He said there's another movement going on right now in the United States, sort of another way that's being explored to get around the popular vote. Let's take a listen.
There's a compact of right now 15 states plus the District of Columbia. Together they have about 196 electoral votes. This compact is looking to get other states to join, and they would have eventually 270 electoral votes, which is what you need to carry a presidential election. What they're trying to do is an end around on the popular vote. All of the states in this compact have agreed, once they get enough states to comprise the 270 votes that you need, they've all agreed that their electors will cast their ballots on behalf of the winner of the national popular vote, not the winner of the state popular vote. So that would be another way of getting to electing our presidents by the national popular vote. It is not without its challenges. There will probably be another Supreme Court case aimed at that, if in fact that does occur. But there is a movement in that direction.
Always something, huh, Vinny? Oh, always something here. So we shall see. And of course, everybody's going to be really closely watching things with the 2020 presidential election right around the corner. So lots of election law to be discussed.
Yeah, I'm just wondering why after more than 200 years we got to change the system. That's the part I don't understand. But hey, who am I? I think it works, right? We've had 40 some odd presidents. All right.
Sure.
Julie Grant, thank you so much. Appreciate it.
Thank you kindly, Vinny.